Okay. Well, hello everybody. Welcome to the first edition of Outline of 2022. If it's not too late, I wish everyone a happy new year. Hope you all had a good break over Christmas, although I'm sure that feels quite a long time ago now. It certainly does for me. So the first topic of the year is the long-awaited Environment Act. I think, thinking back to our very first outline, we were talking about it then, and we've been talking about it ever since. But it is finally with us as of the end of last year. The legislation made its way through Parliament, and we now have the shiny new Environment Act 2021. So just firstly, for some introductions, my name is Trevor Ivory. I'm the UK head of planning team here at DLA Piper, and I'm joined today by a stellar collection of my colleagues to talk about the Act. So we have Amy Truman, a legal director in the planning team, and also another fellow legal director, Ian Graves, and then one of our associates, Henry Jeffries, is joining me as well. So welcome to all of you. And just a sort of quick introduction, really. So why have we got an Environment Act? Well, it's been such a long time in the making. It may be that we've all forgotten why we needed it in the first place. And originally, it was intended to be enacted prior to the UK's withdrawal from the European Union. And it was intended to fill in the gaps that were going to be created in our environmental law framework within the UK by our departure from the EU. Essentially, a lot of our environmental protection legislation is European legislation. Most of that legislation has been carried forward into domestic law as part of the Brexit withdrawal, but there were nonetheless gaps. One of the most obvious gaps being the fact that the enforcer of European environmental law is the European Commission. And they no longer having jurisdiction within the UK, we haven't had a regulator, and we haven't had an enforcer to hold our feet to the fire in the UK since withdrawing from the EU. So that's really where the Environment Act began life, although it's become a much larger beast, I think it's fair to say, as it's made its way through the parliamentary process. It's environmental legislation rather than planning legislation, so a lot of it is not directly relevant to planning, but there are some significant aspects for planning nonetheless, and that's why we're talking about it today. As I say, though, there's quite a lot in it that we're not going to cover today because it's not particularly relevant to those of us involved with the planning system. For example, there are a plethora of targets that are set, or the Secretary of State is empowered to set over various different aspects of environmental protection, and specific mention in the Act to topics such as air quality, water quality, biodiversity, and resource efficiency and waste reduction, but also some very wide-ranging powers for the Secretary of State to bring forward other targets that are designed to protect the natural environment or people's enjoyment of the natural environment. But we're going to put those to one side and focus on the relevant. Now, I've mentioned that there was an issue in terms of who enforces environmental law post-Brexit, and the answer to that in the Act is the creation of a new regulator, the Office for Environmental Protection, the OEP to its friends, a body that has quite wide-ranging powers in its own right and quite a lot to do in terms of dealing with the various different strands of environmental law. I wanted just sort of perhaps to begin though, just by looking at some of those powers where I think there is an overplay with planning. And Amy, perhaps if I can come to you first. I think there is a role, isn't there, for the OEP in planning law, and I'm thinking particularly around strategic environmental assessment and environmental impact assessment, so SEA and EIA.
Yeah, so the OEP's role in monitoring the implementation of environmental law and has a role in looking at the breaches made by public authorities in environmental law. It's clarified a bit in the explanatory notes. So environmental law is legislation mainly involved in the protection of the environment. Now, that doesn't include most of the planning law, but it does of specific things which are concerned with environment, and that it includes strategic environmental assessments and environmental impacts assessments. So in these terms, if there's been a failure to take account of environmental law, the OEP has a function. They can investigate. There's various sort of notices, provisions, and then they also have a new sort of role in making a review, which is a bit akin to a judicial review in certain circumstances, depending on how the notice procedure has gone, or if the breach has some sort of urgency to it.
So how does that play out in the context of a planning application? Say you've got a planning application where you've carried out an EIA. Where are sort of the areas where the OEP might decide to get its hands dirty with a planning application?
So it would be like specifically in relation to that EIA, and anything that hadn't been done properly or considered properly in relation to the EIA itself, rather than any breaches in terms of any other planning law terms. So it would be specific on the EIA regs. And
is it similar for the Habitats Directive and appropriate assessment? Is that also taught?
Well, I think so. The explanatory note doesn't mention habitats regs, but they obviously are there for the protection of the environment, and the Act specifies that includes the protection of the natural environment and plants and habitats. So yeah, I think it is caught. So any breaches of that would also fall under the OEP's remit, and potentially their ability to review in the courts.
And that feels to me potentially quite a significant change. Sort of up to now, the risk that we've all become very familiar with over the years around EIA and appropriate assessment in particular is judicial review brought by a third party who's unhappy with the granted planning permission. Usually, EIA has been quite fertile ground for legal challenges for many a year, as we all know. But it feels as if this is an extra thing to worry about potentially, in that you've got a regulator who, without wanting to be disrespectful to those who judicially review things, usually there's an underlying motive for judicial review that isn't necessarily actually about environmental protection. It can just be objectors looking to frustrate development. But actually here, there's potentially a well-resourced, well-informed regulator who may intervene even if a development's not unpopular in the sort of normal planning sense, isn't there?
Yeah, and I think for third parties who don't have much money but have a reasonable complaint, it gives them the ability to get somebody else to take it on potentially if it was deemed reasonable enough by the OEP. So kind of gives more weight behind that as well.
Yeah, very much so. Well, one to watch. As I say, there's lots of other powers for the OEP, but not so relevant to planning, I don't think. So probably leave the OEP there, just flagging up that new role. And I in due course, once the regulator's been set up, I'm sure we'll start to see guidance and an indication of how they would intend at the OEP to sort of perceive their role and how interventionist they may or may not choose to be. All of that will remain to be seen as we move forward, I guess. But I want to sort of perhaps come on to the big one, and the one that I think we're going to spend probably the rest of the session talking about, and that's Biodiversity Net Gain BNG to its friends, not to be confused with the BFG, two very different things. But for me, I've sort of spent a career, and we've all spent a career being told by successive governments that there are going to be radical changes to the planning system, and all too often when you get the detail, it's perhaps not as radical as we thought, and so I hesitate to use the term radical, but actually I think particularly the way that BNG is to be secured, it is quite radical. So I am going to describe it. I'm going to start the talk by suggesting it's radical, and you will all tell me whether you agree or not, or whether that's just yet another overuse of the word. But I think it is relevant. Whether it's radical or not, others will be the judge of, but it is relevant to anyone who's bringing forward development, whether that's sort of real estate development in the traditional 1990 Act sense, or whether it's promotion of NSIPs through the 2008 Act DCO regime. It has consequences for both. And I think for me, the reason I say it's radical is because it's being introduced as a legal requirement rather than a policy requirement. And that, to me, has quite fundamental differences. Policy there are always exceptions to policy. I mean, we have a long run of case law that tells us that policy is just policy, and in particular circumstances it can be set aside. That isn't the case with the law. So it seems to me the obligations for BNG are unprecedented in planning, in that we have a legal requirement to secure it. That's a legal requirement, therefore it can't be negotiated away through viability type discussions or other material considerations, all the things that we're used to knocking around within the context of a planning application. So it's a legal requirement is where I start, and that, as I say, I can't think of an example of where anything has been secured in this way before. So we need to take it very seriously. But I'd like to start our discussion on it. Perhaps let's start with looking at the 1990 Act and real estate planning in its more traditional form. If we start there, Henry, perhaps I can come to you. What is BNG, and how, in the context of a planning permission, is it going to be secured?
So at a conceptual level, Trevor, I suppose biodiversity net gain is an approach to development that's looking to leave biodiversity in a better state than it was prior to that development taking place, in simple terms. And I think, as you mentioned as well, in terms of the concept of biodiversity gain, that's already present in the NPPF. So it's a familiar concept. It's just a question of how it's now being secured. And the key point there, as you said, is that the Environment Act is making biodiversity gain illegal rather than a policy requirement. So in terms of how that's secured for development under the 1990 Act, the Environment Act makes a number of amendments to that Act, and that includes a new schedule. So that provides for the inclusion of a deemed condition on planning permission in England, subject to certain exemptions, to preclude commencement of development until a biodiversity gain plan has been submitted to and then approved by the local authority. So that the use of a deemed condition is interesting in itself. It's fairly unusual, and both the explanatory notes accompanying the Act and also there was a consultation document published by the government last week, and both of those acknowledge that due to the deemed nature of the condition, potentially it could be satisfied on the grant of permission where a biodiversity gain plan was submitted alongside the application, as opposed to having to be satisfied post grant of permission. So I think there's an interesting point there as to sort of in practice whether we see it being satisfied ahead of time or post grant of permission. But in any event, I think the key point for today is that the biodiversity gain plan will be required by a deemed planning condition, and then it's the biodiversity gain plan which will then secure what the Act calls the biodiversity gain objective.
And that is a really important point, isn't it? I want to come on to biodiversity objective, but just before we do, it is a big point that I sort of really want to stress and get across to people, that whether your planning permission moving forward has an express condition on it requiring a biodiversity plan or not, that condition is being read into, it's being implied onto those planning permissions by law. So whether it's actually there on the face or not is not relevant. You're going to get caught. I think it comes back to that radical point. That is quite radical in terms of securing things. We've lived with the deemed condition dealing with implementation and time limits for doing so with that, but that's a very different thing. That's just a sort of technicality, isn't it? Whereas this is fundamentally, it is a requirement being imposed on a developer, regardless of whether the local authority actually puts that condition on the face of the permission or not. It doesn't, just sort of covering that, it doesn't apply immediately. It's coming in, and we'll come back perhaps to talk about sort of when all of this comes in, but once it's in force, that deeming will be automatic. But sorry, I've sort of cut across there. You mentioned the BNG objective, Henry. What is it?
Yeah, so I mean, the BNG objective is essentially the measure of how you secure biodiversity net gain. So the Act says that the objective is met if the development's biodiversity post-development exceeds the pre-development value by a certain percentage. Now, under the Act, that percentage is set at 10%, and that's the figure that's been widely publicised to date, I think, sort of in anticipation of the Act as well. There is provision in there for the Secretary of State to raise that percentage or indeed lower the percentage, but I think we're very much expecting that to be 10%. So that gives the level of increase required at a relatively high level. However, underlying that 10% increase, there are a number of different metrics and measures as to how you ascertain that in practical terms, in terms of the habitat on site.
And how is it measured? And how do you begin to provide this gain?
So this is the dark art of measuring habitat value. So in the Act, it states that biodiversity value will be calculated in accordance with something it calls the biodiversity metric, which is to be published subsequently by the Secretary of State. Now, it's not specified in the Act, but the widely held expectation is that that metric will be the Natural England's Biodiversity Metric 3.0, which has been published the summer just gone and is going to supersede the 2019 version 2.0. So as a result, the expectation is that the metric 3.0 is going to provide that methodology to measure biodiversity value both before and after development. So in terms of that post-development biodiversity value, the Act states that that includes the value of on-site habitat post-development, registered off-site biodiversity gain, and also any biodiversity credits that have been purchased in relation to that development. So further information on each of those three categories of biodiversity value is provided in the consultation published last week. And that makes clear that irrespective of the option for off-site biodiversity gain, the mitigation hierarchy would still apply. So essentially, the order of priority for developers to consider would be looking to avoid any negative impacts in the first place. If they can't avoid negative impacts, it's a case of mitigating on-site. However, where that's not possible, there's then the option of off-site provision or the purchase of biodiversity credits, which is a financial system which would then be used to provide biodiversity elsewhere.
And are there going to be any exemptions from this, Amy, or does it apply to all planning permissions?
There's a couple of explicit exemptions contained in the Act. So one for planning permission granted by development order, so any permitted developments, including any prior approval PD, and also any urgent Crown development. Those two things are exempt. And then the consultation document, which Henry referred to, also proposes some more exemptions, which you'll see coming through in secondary legislation. So that talks about exempting householder extensions, any development which has a habitat area below a de minimis threshold, any change of use applications. Those 3 points are quite certain about, and then they're also considering exempting on self-build and custom build house building, and on the creation of biodiversity gain sites. So they're looking at, in that case, specifically making it only projects which will enhance biodiversity for the point of providing net gain. They're quite concerned that there's no loophole. So if you had a general development providing biodiversity net gain, that wouldn't be exempted. But if you had a specific like biodiversity net gain site, that would be exempted. I think previously they may have been talking about exempting brownfield sites, but they're no longer looking to do that. The justification they use for that is that they want the BNG to benefit people as well as wildlife. It's quite an interesting point, which perhaps we forget about when we're thinking about biodiversity net gain, that there can be that benefit to people and well-being. It's not looking at exempting temporary permissions, but I think that the metric does that to a certain extent in itself anyway. You had a very temporary permission and the losses were going to be restored within 2 years. Then I think it would it looks like it would fall into being exempt just by the metric rather than by anything else. Also, they're not going to, they were talking about exempting in conservation areas and national parks where development should have been permitted development, but wasn't by the virtue of its location. But that has been dropped as a possible exemption, I think, in the consultation at the moment. So
it's all quite up in the air, isn't it? Because obviously it's a consultation,
well,
so
yeah,
we won't know what the final outcome is. But I think it seems to me, from what you're saying, there aren't going to be very many exemptions for any significant development.
no,
It feels as if it's sort of, it's household or extensions, it's that sort of stuff. But in the main, thinking about our audience today, probably involved in more significant development, we're going to get caught, aren't we?
yeah. Insignificant development, even significant development on brownfield sites, will be caught unless you fall into the de minimis exemption, I think. So there is a de minimis threshold, and that's not to do with the size of site, it's to do with the sum of the habitat types on a development site. So you could only fall into it if you had low or medium value habitats. So if you've got a priority habitat, you wouldn't fall into the de minimis anyway. And it's talking about vegetation and barer surfaces. So, I mean, potentially some brownfield sites might be able to fall into it, because if you had a concrete or existing structure there, that wouldn't be a habitat. You might be able to just come under, but depending obviously on your site.
And what happens if you've got, you sort of mentioned the different values of existing habitat. What happens if you've got sort of irreplaceable habitat? I don't know, scheduled in woodland or something like that. How does that get picked up through the system?
Yeah, so the consultation document talks about the irreplaceable habitat, and taking that out of the BNG because it's habitat that you can't replace. So the biodiversity net gain just wouldn't count for it. So I haven't yet defined what is an irreplaceable habitat, but there is a definition in the NPPF. So it looks like probably be things like ancient woodlands, ancient veteran trees. There's a list of specific habitats that would fall into it. So then you would have to, if you were going to cause an issue with irreplaceable habitat, you'd have to have your compensation for that agreed specifically for that irreplaceable habitat and not falling under the BNG.
Okay, thank you. Ian, you've been unusually quiet. Assuming you're there and can hear us, it's about time you did some work. So perhaps I can come to you. Just sort of fill in the gaps in terms of the 2008 Act, because there is a different approach being taken, isn't there, in terms of BNG?
Yeah, that's right. I mean, I think the basic principles that sort of Henry and Amy have described are are still relevant. But I mean, obviously, the process by which that has been or that will be implemented is slightly different. I think just sort of taking into account the different consenting processes under the 1990 Act and the 2008 Act. So, I mean, in terms of nationally significant infrastructure projects under the 2008 Act, the way that this is implemented is through a system of biodiversity gain statements. And I'll go on to talk about that a little bit more in a second. But what the Environment Act has introduced is effectively a bar on the Secretary of State from granting a development consent order where there is a biodiversity gain statement in place, unless he's satisfied that the biodiversity gain metric is the biodiversity gain objective rather is met. And again, that is 10% currently, although that can change in the future. So, I mean, the way that that this is implemented is slightly different, although it's the same sort of principles. I should say that this only applies in England at the moment, and at least initially it doesn't apply to the marine environment. So obviously there are a lot of NSIPs at the moment that involve offshore wind and various other sort of projects in the marine environment. They're not included at the moment, although there is sort of potential for them to be extended. And again, as Amy was sort of outlining there, there's a similar sort of provisions allowing for exemptions in terms of infrastructure development. Although the consultation document's quite clear that the government doesn't sort of isn't seeking to introduce amendments, exemptions rather. That is something that is being consulted on at the moment. So if we've got clients that are interested in infrastructure development, it's certainly worth looking at the consultation document. And if you think that there are exemptions that should be introduced, then certainly give that feedback. But what the government seems to be saying is that what it would seek to do is to require a lower percentage of BNG rather than an exemption in certain cases, which is a sort of clear commitment to applying the principles in terms of infrastructure development, which is interesting. Quite a big sort of progression actually, because of course initially infrastructure development wasn't included in the first sort of drafts of the Act.
And it's potentially in the context of infrastructure, it becomes a big number, doesn't it? If you're trying to secure BNG, if thinking railway lines, roads, and things, it's a big project with therefore potentially a big impact. So it's going to have quite an impact, I suspect, for promoters of infrastructure in terms of having to think right from very early on about how they're going to deliver that biodiversity net gain.
I think that's right. And I mean, again, if you look at the sort of consultation documents, I think there is a sort of recognition there that that infrastructure is slightly different. I suspect that that's one of the reasons that marine development's not yet included, is because clearly the way that biodiversity gain is is calculated will depend to a certain extent on what is lost. And the value of what is lost, and obviously in some marine environments, you're talking about extremely valuable habitats that are difficult to replace. So I suspect that things like the system of biodiversity credits will be very important in terms of infrastructure development. And obviously we don't yet sort of have the detail of that. So I think it will be difficult for projects often to demonstrate that at this stage. There is intended to be quite a long lead in time, though. I think the consultation document's talking about sort of mid-2025, I think, as the point where biodiversity gain statements will be in place, and so promoters of infrastructure development have got quite a long time to think about how this applies to their project, where projects are sort of still in development.
And so the biodiversity statements, just if we can come back to those, how are they going to be introduced, and what is it they're going to include?
So there's two ways. I mean, what the Act says is that following it coming into force, the first time that a national policy statement is reviewed, the Secretary of State is obliged to include a biodiversity gain statement in the new NPS effectively. But I mean, there is a sort of alternative route. So where there isn't an NPS, so there still are certain types of development where there isn't a sort of a relevant NPS, or where the current NPS doesn't contain a statement. Basically, what the Secretary of State can do is issue a separate biodiversity gain statement, and then that is then sort of treated as being incorporated into the NPS. And I sort of that's obviously a device to avoid the Secretaries of State having to carry out like wholesale reviews of current NPSs. I mean, some of the current policy statements are quite old. Some are under review at the moment. So eventually, every NPS will include this. But in the interim period, I think we can expect to see some sort of standalone statements being adopted that, as I say, will then be treated as incorporated into the NPS. The idea of the BNG statement is effectively it will set the BNG objective for the particular type of development and sort of set out how that will be calculated. So there is sort of scope for different types of development to have different requirements. The statements are also going to contain details in terms of what evidence applicants for DCO will need to provide with their DCO application. So, you know, I'd anticipate that there'll be some clear guidance as to how we prove or how we demonstrate that we're meeting the BNG objective. And then also there can be provisions that relate to any sort of measures that must be included in a DCO to counter effect of the sort of relevant development on-site habitat. So, and that sort of seems to envisage, you know, how particular types of habitats will be treated. And I mean, you know, if you read a national policy statement, you know, quite often there will be sort of specific sections that deal with types of habitat. So ancient woodland, for example, is a pretty common one. So I'd imagine it's going to be a sort of extension of the current system.
And Henry described the sort of measuring of BNG as a dark art. Is it the same dark art in the context of the 2008 Act, or is it a different dark art altogether? How's it measured? How's it valued?
Well, again, it's the same sort of principle. So what the Act envisages is a calculation in accordance with a metric, and as I say, the biodiversity gain statement will set that out. I mean, under the Act, it's quite flexible. So, you know, each BNG statement could have its own metric in theory, or, you know, the metric that for the Town and Country Planning Act development that Henry was just talking about could be used, or, you know, the Secretary of State could publish a different metric that deals with infrastructure development. So it would be, you know, yet to see how that will come about.
So coming back to our professor of the dark arts, this metric, or there may be more than one, but the metric is clearly going to be really important, isn't it? But Henry, what do we know about it so far?
So, I mean, as mentioned earlier, the purpose of the metric, it's designed to calculate the existing baseline value of a site and also the predicted future baseline biodiversity value. So the metric 3.0 was published in the summer. And since then, we've already been discussing its application to different habitats and its potential habitat to different habitats with a number of different clients. And what's become apparent from those discussions is that, particularly in relation to more unusual habitats, there are potential areas where the metric raises viability issues where it doesn't quite cater for those habitats. So it's an emerging document, so it's understandable that there are potentially elements of it that are still requiring further work, but that's potentially significant given that if it's adopted under the Act, the metric is the measuring stick for what in practical terms constitutes that 10% net gain. So helpfully, the Act does require formal consultation on the metric before it's brought into force for the purposes of being the metric under the Act. So there's an opportunity there to engage with the Secretary of State and with Natural England in relation to any specific habitats which are seen to be causing any issues. But in addition to that, Natural England's website states that they're looking for feedback and engagement ahead of that formal consultation. So there's also potentially an opportunity there to be getting involved and raising issues ahead of time.
Thank you. And timescales is something that I said earlier we'd come back to, and actually we've had a question about timescales come through as well. So if we can perhaps just look at that next. Big question, Amy. When's it going to come into force?
Well, so Ian mentioned they're talking about 2025, the NSIT. Actually, the press release that was issued with the consultation suggests a quicker timescale for the 1990 Act, that stuff to come through within 2 years of Royal Assent. So we'll be looking at November 2023 for that at the latest, if they keep on track.
But I suppose there's always with these things, it's how long's a piece of string, doesn't it? Because if the government gets distracted, I don't know, maybe they've got other issues that they become focused on rather than the Environment Act. There's always the potential for that to slip, isn't there? I think.
Exactly.
Yeah. But let's move on from any issues the government may or may not be distracted about round about now. That feels like a dangerous topic for us to get into this late in the session. But there is so 1990 Act, November 2023 is sort of long stop ish. And then 2025 for NSIPs, Ian, but there is some significance, isn't there, Ian, to the end of this month, which is the 31st of January?
Yes, I think it's the 30th of January 2020. Trevor, I think is the relevant date.
Losing track of my years.
That's right. I think the significance of that in terms of the Act is that's the date that the bill was published. But basically, what the Act sort of aims to do is to prevent the sort of the loss of biodiversity value on sites sort of ahead of the Act coming into force. So what the Act basically says is that, you know, any activities that a person carries out on land on or after that date, so 30th of January 2020, unless they are activities that are carried out with planning permission or that are sort of otherwise exempted by the Secretary of State in regulations, and those activities reduce the biodiversity value of the land, then it's the pre-development biodiversity value that's going to be taken as the value that existed prior to prior to development taking place, if you see what I mean. So the idea is, you know, if you've got a site and a landowner has gone on and, you know, cleared it of nice grassland or other sort of valuable habitats in anticipation of the Environment Act coming into force, well, unless that was done in accordance with a planning permission, or it's, as I say, it's exempted in some other way by regulations, then it will, that loss of biodiversity is not going to be taken into account. And it's going to be the biodiversity value before those actions were taken that will be considered when it comes to sort of future applications for planning permission or, I suppose DCO in appropriate cases. So it's really, the idea behind this is to stop people sort of gaming the system and trying to sort of reduce the value of sites before the Act has come into force.
This is a really important point, it seems to me, and sort of one when the penny dropped for me, sort of the jaw dropped with it, because it is not unheard of, perhaps, if you're preparing a site for planning, if you do certain things that might cause you a problem through the planning application process, to the extent they're not legally protected. It's not unheard of for these things to perhaps not be there by the time but by the time you come to a planning application. Now, I suppose there's nothing preventing that from happening. Trees that aren't protected, if they're removed in order that they're not a barrier to a planning application, as an example that I've come across in the past. But it's a really big point. You can still do that, but what that won't do is reduce your starting value, your biodiversity value. So your 10% improvement is going to work on the basis that if that tree or that whatever was there back at end of January 2020, get the year right this time, then you're still going to have to factor that into that calculation. I think that's a massive point, actually. And does that date move, or in 10, 15 years time, do we still look back to what sites were as at 30 January 2020?
I don't know, actually, Trevor. I mean, I don't think so. But I must be honest, I'm not. I don't know that bit of the Act well enough to be able to say whether there's power to move the date. I suspect not. I think that the sort of principle behind it, as I say, was to just stop people thinking that they could get ahead of the curve, sort of thing, and and take steps before the Act came into force to reduce value.
It's certainly not immediately obvious to me that it moves. I don't know. Henry, I know you've looked at this a little bit.
No, I haven't seen that it does move, Trevor. And I think the point Ian made is that it's linked to when the bill was announced, wasn't it? So I think the whole purpose behind that is as soon as the obligations that were going to come into force became apparent, there's then that bar put in place from the outset, isn't there?
Yeah, and we've had a question come in, sort of picking up on that, which is a really good question. How are we going to establish this? Once things have been removed, where's the burden going to lie in terms of proving what the condition of the site was on the 30th of January 2020?
I mean, it's a point I was going to make when I was commenting just now. Actually, I mean, there is an issue about evidence. I mean, I suppose in principle, councils could require applicants to tell them, perhaps, what was the state of the land on that date. perhaps it'll be something that that'll be sort of dealt with in regulations in terms of what needs to be demonstrated by applicants when they're sort of putting in their biodiversity statements under the deemed condition, for example. Perhaps that will be something that needs to be included as a detail of the means of satisfying BNG. So it's a really good question, actually. Something I'll go away and look up after the session.
I think that's right, though. The consultation that was published last week in particular talks about the various different things which have to be submitted alongside that biodiversity gain plan for 1990 development, at least. And I think the point on there is that the evidence is very much on the developer. The onus, sorry, is very much on the developer to provide evidence to support their statements of pre-development value and also post-development value. So I think that is right.
There's as ever when we get new legislation, the first thing the lawyers start to spot is all the potential challenges and the disagreements and the JRs over what it all means. You certainly hear, it feels like this is one of those areas where there's bound to be a role for the courts in trying to answer some of these questions where the legislation perhaps has not done it necessarily clearly. So we're getting a few questions coming through. I'm going to try and factor them in, but just one thing, Amy, if I can come to you first. I think, how's BNG going to work in the context of larger permissions? I'm thinking particularly those that are phased. What's going to be the implications of the BNG condition for a phased permission?
Yeah, I mean, this is again something that's coming through in consultation, and a lot of it I don't think is particularly different to other stuff that we would do on a phased permission. So they would be asking for a sort of upfront strategy of how BNG is going to be dealt with across all the phases as I think things are being brought forward, thinking in particular of developments where you've got reserve matters for different phases coming forwards separately. You would need to be making sure that there was a strategy to be implementing your BNG throughout these reserve matters on the various phases, and also looking at, they're talking about looking at sort of the sort of almost like the parameters or the rules that would need to come through with each reserve matters, which I think is something that we often see on EIA development anyway, with parameters and design codes. So it just gives another strand of that it would have to be considered upfront for BNG. But what I think is perhaps something that people might want to engage about is how the BNG is delivered, because at the moment they're looking at sort of similar to what we were talking about on the 30th of January 2020 date, that the biodiversity for the whole site would be looked at the beginning of the whole of the consent for the whole of the phase development, and then that is what you would need to provide your BNG for. But then on the plan or the proposals, they wouldn't deal with it so much on a phase by phase basis because they want it front loaded. So you would provide more in your first phases. The concern that is mentioned in the consultation is that later phases, what if they couldn't deliver it or didn't deliver it or didn't come forwards? And so they're looking at sort of front loading it. So I guess in your first couple of phases, you could end up having to provide not 110%, but a greater percentage tailing off through the development. So that's something to be mindful of and perhaps engage with the consultation on.
Yeah, and certainly has implications for landowners that are looking at securing an outline permission and then looking at possibly selling off in phases to different developers. That kind of, we're always looking, aren't we, when we're structuring 106s and planning conditions to try and keep that as clean as possible, so that each phase can be just standalone. Because we all know developers don't like having that sort of interconnected contractual relationships across phases where it can possibly be avoided. But it feels as if here this is potentially one where that is going to be more tricky, and actually there may need to be a bit of a thought early in the process as to quite how that's going to allow that sort of disposal process to work. I'm conscious of time, and we're getting lots of questions, which is good, but we need to keep to time. So I'd like to sort of turn to offsite and credits, where we've had a couple of questions coming through. Ian, if I could perhaps start with you, because I think you mentioned both before. Can I start with offsite? How is offsite provision going to work?
So it's going to work through something called registered offsite biodiversity gain, and I mean, basically this is sort of habitat enhancement that's secured in some way. So you know, it's either under a conservation covenant, which is another sort of facet of the Act that we haven't sort of covered yet, or under a Section 106 agreement. And then it has to be recorded on a biodiversity gain site register. So there'll be a register of these sites, and basically sort of biodiversity gain from the site can be allocated to a specific development. But the sort of, I suppose the key takeaway on that point is that it's got to be formally secured. These have to be set up as registered sites, and secured in some way in order for them to be able to count as registered offsite biodiversity gain. So you know, if you're a developer, you know, that owns land elsewhere or whatever it is, you would have to set that site up specifically on the register and give a commitment to providing the relevant sort of biodiversity improvements on the site in order for that to count as part of the biodiversity net gain calculation.
And is it local planning authority boundary blind? Could you offset in authority area A for a development you're bringing forward in area B, or can the local planning authority say, no, I want that offsetting within my administrative boundary?
Certainly, I mean, my understanding is that it can be offset anywhere, but the sort of, if it's offset elsewhere, the distance, if you like, would be taken into account in the biodiversity met by the biodiversity metric, if you see what I mean. So, you know, further away may mean that you know, you don't get as much credit for that site as if it were on site or a nearby site.
And just pushing that a little bit further, national borders, you know, could I secure an area of the rainforest in Brazil and call that off-site or not?
Well, we had a client ask us this recently. I thought it was a you know, a good question, but I mean, I suspect that the restriction on that is going to be the requirement that it's carried out under a conservation covenant or a 106 agreement, and of course they would only apply under the Act and under the 1990 Act in England. Or England and Wales in terms of 106 agreements. So, you know, I think it is likely to be only on these shores, unfortunately.
Okay, and the credit system. What is this credit system, and what's it going to look like?
Yeah, so I mean, it's not sort of completely clear yet exactly how the system of credits is going to be set up, and actually that's one of the key things that that's being consulted on at the moment. So the details are going to be set out in regulations, but I mean, effectively, it's what it sounds like. So developers will be able to purchase credits that sort of have a biodiversity value, and then use that value to offset impacts and to sort of provide gains on their site. I mean, when you know, reading the sort of the consultation documents, I mean, it seems very much as though the government is envisaging a market in these credits, and so you know, it seems very it's described in a very broad way. So you know, any landowners can you know, provided it's done in the appropriate way, can provide gains on their site that can then be sold as credits. And there's you know, talk of planning authorities, for example, also getting involved in this, or maybe acting as brokers, for example. So it seems that the you know, the intention is that this will be a sort of a very broad-based market in these credits, which you know, I think is sort of actually quite a sort of exciting development potentially. I think particularly if you're a you know, if you are a landowner that perhaps has got you know, that has land that's suitable for this kind of use. You know, it is potentially a way of obviously sort of bringing in some money to aid with the sort of the management of that land. One of the things that the consultation document does say is that you know, the government's considering providing in the first instance sort of a system of what it describes as statutory credits initially, sort of as a last resort, because I think the sort of anticipating that it will take a number of years for the market to develop and for these credits to be available through the market system. So I think at least initially there will be statutory credits that the government provides, obviously for this purpose, and the money from that under the Act can only be used for sort of specified purposes around administering the system and for other sort of environmentally beneficial purposes, if you like.
So it feels like it's similar to the kind of carbon trading schemes that we've seen over the last few years, sort of, and carbon credits. It's that sort of approach, isn't it? If someone's creating a gain, then they're able to sort of effectively sell the benefit of that gain for someone who is struggling to meet the BNG requirements for their development.
I think that's right. Although it's not a sort of a cap and trade system, which the sort of carbon credits would be. So it's an open system. So which I suppose is designed to sort of encourage the maximum amount of gain that we can we can get through the system. But I mean, I think the hope is that it would be quite flexible in terms of obviously meaning that developers where it's problematic to provide the gain on site, it doesn't mean that development is completely blocked, but it does also give landowners another option in terms of bringing in money to maintain land. And I suppose from the point of view of local communities, I mean, we don't know how this will develop yet, but I mean, it may be that some areas that are being used for BNG credits might be open to the public and might provide green spaces and so on that the public can visit perhaps. So it seems as though it's a real could be a real win-win system if it works in the way that's anticipated.
Henry, you're something of an expert on SANG's, suitable alternative natural green space, which is a concept that's been around for some time now, and it feels as if there's some similarities perhaps with the credit system, and I wonder, are there some opportunities here, both in terms of offsite provision and credits? Are there some opportunities for landowners?
I think there are, Trevor. I mean, Ian touched on that briefly, in that there's obviously a need for offsite provision, so someone needs to provide that. And I think while the preference expressed in the consultation materials is very much for on-site provision, there's undoubtedly going to be a need for offsite, and also land to have the funds generated by credits to be assigned to. So I think as a result, there's potentially opportunities both for landowners and also for local authorities. As Ian mentioned, the consultation envisages that local authorities can provide offsite biodiversity gain sites as well. Interestingly, in the consultation document, it's envisaging that habitat created or enhanced after 30th of January 2020 would be eligible for registration as well. So it's not just a case of habitat enhanced going forward, there's potentially a backdated element to it as well, which expands that window of opportunity. I mean, I think that another interesting point really, and it's not entirely clear yet, is the question of whether, if a developer in providing on-site biodiversity gain goes above that 10%, can they then allocate the additional percentage to another site, be that one of their own sites or to a third-party site? And that's touched upon in the consultation. It's not entirely clear, but at the moment, the statement from the government is that they're minded to allow that approach to be used. So potentially there's the opportunity there to go above and beyond on one site and benefit on another, either financially or in terms of satisfying the objective. I think it's worth noting that the opportunity here is subject to obviously the offsite provision meeting the requirements for registration, and also it being secured for 30 years of maintenance. But an interesting point to look at, I think, now ahead of time, is that amongst those consultation materials, there's actually a market analysis provided by the government on a local authority by a local authority basis, which sets out the anticipated demand in each of those areas. So if you are a landowner or a developer in those areas, potentially you can look now ahead of time and identify where those areas of need might be.
Sort of as you're talking, it's reminding me back in the day, you saw, in the context of residential development, you saw if you had a prime site in a high value area, you'd see a developer also bring forward at the same time a site in a lower value area and say, I'll put all of my affordable housing on that low value area in order to maximize values. And sort of we've moved away from that mixed communities and all of that. You don't see that quite so often anymore, but it almost feels like there's a similar situation there. If you're bringing forward multiple developments, actually potentially you've got an opportunity to deliver your gain on those where it's perhaps easier or perhaps less expensive to deliver it, and sort of preserve the value of perhaps the other site. Yeah. Okay. Well, Henry, while you're talking, I'm just going back because we've had a question come through around the condition, the implied condition. The question is if by the time all of this comes into force, you've got an outline permission, but you then subsequently, post everything coming into force, you go for reserve matters. Would the condition would the condition be imposed at that stage? I think the answer is no. I think it gets imposed at outline stage, doesn't it? But
my understanding would be it's at the outline stage. I suspect it's something that's picked up in the consultation document, which fleshes out the requirements in the Act. But I don't know off the top of my head is the answer. I don't know if Ian or Amy have seen that.
No, obviously in when it was talking about phased developments, it very much appeared that it was on the outline that you'd have that condition, but I haven't seen anything else. So
yeah, that's certainly, to an extent, the detail will need to come forward, won't it? But it certainly feels to me that it ought to work at outline stage. So if you've got your outline consent prior to the system coming in, it feels unlikely that they're going to try and impose that condition and sort of almost retrospectively look to secure BNG from reserve matters when it wasn't envisaged at outline. Okay, we've got just a couple of minutes left. So one really quick question, Ian, if you can kind of answer it in 30 seconds, I'd be delighted. On a slightly different topic, which is what flexibility is there for a planning authority who wants to move further faster than the Act? And I'm sort of asking that in the context I know I've seen, and I suspect you have, some local authorities looking to bring forward planning policies. I think there was one in Planning Magazine last week that was looking to bring forward planning policies that either are trying to secure this in advance of the legislation, or in fact are looking for a higher percentage than the 10%. What's the scope for local authorities to do that sort of thing?
Yeah, I think that's right. I mean, certainly we're aware from other work we're doing of a number of authorities that are arguing for sort of 20% net gain as being the appropriate figure. And as you say, Planning Magazine, I think earlier in the week, it included two local authorities that have included that in an SPD. I mean, I think it's a plan-led system, isn't it? So I mean, I think greater targets adopted through the local plan system, I think, are okay, although of course they will be policy requirements and not legal requirements. I think outside of the plan led system, I think local authorities are going to have difficulty in arguing for a greater degree of gain that is in the Act, because of course that is the current legal requirement. So I think it'd be difficult to sort of try and argue for that on the basis of sort of material considerations or so on. So I think local authorities will need to look at including those sort of provisions in their planning policies as they develop local plans or supplementary planning documents.
And I suppose it's back to that radical point I made at the beginning there, isn't it? Policy, there are always exceptions to policy, whereas the legal bit, we've got no choice. We're stuck with. Okay, well, look, thank you. We are bang on the hour, and we do try to finish within the hour. So I'm going to bring it to a close. But perhaps, can I bring it to a close? I'm going to give you each an extra 30 seconds, if the audience will indulge us. An extra 30 seconds. What from each of you? What's the one thing that you think people should take away from the discussion we've had today? Just because you're at the top left of my screen, Henry, I'll come to you first.
That's very kind, Trevor. So I can steal Amy and Ian's thunder. I think the key thing for me is being proactive. So obviously we've spoken about the dates for enforcement, but actually both in terms of managing risk and engaging in consultation, and also in terms of taking advantage of opportunities. I think if you can get ahead of the curve, now's the time to be looking at those things.
And easily within 30 seconds. Well done. Ian.
Yeah, I suppose just picking up on that. I mean, my main takeaway would be about the metric, actually. So, obviously we've talked a lot about the legal provisions and so on. But the way that this is going to operate will be very heavily dependent on how the metric works. So I think, what I've been saying to clients is, look at the metric now. If you've got sites that are under consideration or that you own, see how it would affect that site. What would you need to provide? How would that affect viability? And think about that now, because there will be a consultation on the metric before it comes into force. And it's really important that that DEFRA and that the government generally have real world feedback from developers that shows how the metric will operate in terms of viability and so on. So I think that would be my key takeaway.
Yeah, that consultation is going to be key, isn't it?
I think so. Yeah.
But once this system's in place, we are stuck with it. There's no getting around it. So we need to be engaging with that consultation to try and make the system practical and workable. Amy, the last word for you.
I think there are some positives to it. There's if you've got the right kinds of site, you might be able to create some BNG and be able to sell that on. Might even be more opportunities to invest. Anyone who's adding some BNG to their sites is perhaps making it more attractive. To remember that some of it's for well-being and population, as well as our nature. So there are some positives there, albeit they might seem hidden if you're looking at bringing forward a residential development.
Always good to end with a positive. Not always easy in a legal seminar, is it? But always good to end on a positive. So thank you to all three of you. I think it's been an interesting discussion. There's a lot there, and we've covered a lot of it. So well done. And thank you to those of you that joined us for the live broadcast today. As ever, we'll upload the recording to the YouTube channel. So if you enjoyed it that much, you can watch it again, or share it with your friends if you think that they would equally enjoy it. But other than that, thank you all very much for joining. We'll be back next month. Next month, we're going to have a look at some interesting cases that have happened over the last few months that we think you need to be aware of. So it's a case law review for February, and I very much hope you can join us then. But in the meantime, goodbye.